And so without further ado, I'm going to hand this off to Sarah and Siobhan from Case Western Reserve University. Again, welcome. Thanks for being here.
Hi, everyone. I want to echo the thanks. We really appreciate everyone who is here today, and we also appreciate everyone who is tuning into the live stream. So thank you to everyone for coming out. My name is Sarah Coulter. I'm a senior fellow in the First Amendment Clinic at Case Western Reserve University School of Law in Cleveland. Also here today is Siobhan Gerber, a fellow in the clinic, and unfortunately, our director, Andy Geronimo, was unable to make it here today, but I know he's tuning into the live stream. So we all just want to thank you so much for coming out today. I know it's a Friday morning, it's maybe a little rainy outside, so we really appreciate it. So obviously we work in the First Amendment Clinic. The First Amendment is really the bread and butter of what we do. You know, whether we are representing someone who was censored or silenced by the government for their speech, or the government retaliated against them for their speech, or we are representing someone who was sued for defamation for something they said online. It's almost always on Facebook, so just be careful when you're using Facebook. But we obviously use the First Amendment every day in our day-to-day lives. Obviously, we're here talking to you. A lot of you are journalists or aspiring journalists, and the First Amendment is super critical for all of you as well. The Supreme Court has recognized that a responsible press has always been regarded as the handmaiden of effective judicial administration. The press doesn't simply publish information about trial, but it guards against the miscarriage of justice by subjecting police, prosecutors, and the judicial processes to extensive public scrutiny and criticism. So we appreciate everything that you do. We have worked with journalists before. We have represented student journalists who have been sued for their things that they have said in articles. We have worked with journalists doing pre-publication review, and so we're really excited to be talking with you all here today. Just to give you a little bit of background about the clinic, Andy, Siobhan, and I are lawyers. The people that are leading the presentations today are our certified legal interns. So they are in their third and final year of law school at Case Western, and I'm sure that they are very excited to be almost done. They are going to be leading the presentations today. They act as certified legal interns in the clinic, which means they do first chair legal experience on behalf of our clients and represent them in court, in discussions with opposing counsel. Anything that we do, we can supervise them to do in court. So just to give you a quick agenda before I turn it over to them, we will be leading trainings on editorial discretion and control and prior restraints, school speech, court access, news gathering, and defamation. There will be question and answer opportunities after each presentation, and also please feel free to come grab us during breaks, lunch, or anything if you have any questions or if there's anything that you want to talk about. Finally, a huge thanks to Andrea and OU and the Post for hosting this event, Jonathan and Corinne and the Athens County Independent for all the help planning the event, and to the Revada Foundation, the Tyler Weymouth Endowment for funding the live stream, and Andrew. Finally, just a quick legal disclaimer. Nothing here should be taken as legal advice. The issues that we're going to be talking about are complicated, very fact-dependent. Obviously, we can't teach you everything that you would need to know just today. So just keep that in mind. We hope that what we're doing here today helps you recognize when it's a time that you might need to reach out to a lawyer about your First Amendment rights. So with that, I'm going to turn it over to our first presenter, our certified legal intern, Neka. She actually had a final last night in her trial tactics class and drove in at 10 p.m. So we're really excited to have you all here, and we're excited for Neka to do this presentation.
All right. Good morning, everyone. Thank you so much, Sarah, for the introduction. My name is Neka Anyakwulaje. I'm a certified legal intern at Case Western School of Law. I'm going to be giving you a presentation today about editorial restraint, editorial discretion, and prior restraint. So let's go ahead and get started. But if you have questions at any point, please feel free to just let me know. All right. So being that I'm sort of starting this off, I want to give a little bit of background about why editorial discretion and prior restraint is so important to the First Amendment. But I want to let you know that throughout this presentation, I have a couple of quotes peppered in to really hone in on the importance of these issues and why they're so relevant to the First Amendment and how the First Amendment is so relevant to our democracy. So, what is editorial discretion and prior restraint? So, editorial discretion is a journalist's ability to decide what to print and how to cover newsworthy issues. Prior restraint is a government attempt to suppress material that would be published or broadcast on the grounds that it is unlawful or harmful. Now, why are these concepts so important? These concepts are fundamental because they're laws protecting your right to editorial discretion and protecting you from attempts to silence or influence or regulate your journalistic power to determine what to and what not to publish. And this is at the heart of the First Amendment and your freedom of expression. Additionally, there are numerous cases that the Supreme Court has indicated that the Constitution establishes a strong presumption against prior restraints and in favor of your right to editorial discretion. And lastly, the laws around editorial discretion and prior restraint are still developing. And so that's something that we'll spend a good portion of this presentation discussing as well. All right, so let's talk about editorial discretion. So first, I want to give a little background as to what some of the foundational laws regarding editorial discretion are and how these give us an insight as to what the Supreme Court thinks about our rights to editorial discretion. So the first case, CBS v. Democratic National Committee, was litigated in 1973. And here the court held that neither the Fairness Doctrine, which essentially requires broadcasters or publications to post about the other side or publish about the other side of political issues. So they held that neither that nor the First Amendment requires a broadcaster to accept paid editorial advertisements because the opposite result would infringe too much upon their journalistic discretion. And so Chief Justice Berger explained that it would be anomalous for us to hold in the name of promoting the constitutional guarantees of free expression that the day-to-day editorial discretions of broadcasting and licensees could be constrained. Now, the second case is one that's very foundational and fundamental to editorial discretion, and that is Miami Herald Publishing v. Tornello, and that was litigated in 1974. So in Miami Herald, the court held unconstitutional a right of reply statute that would have forced newspapers to publish the replies of political candidates to critical editorial content. It held that the First Amendment prevents government from regulating newspapers' exercise of editorial discretion, essentially the decision about what to post or publish and how newsworthy an issue is. Without this protection, the court said that the government could censor what people are allowed to read and know. The next case is Manhattan Community Access Corp v. Halleck, and that came out in 2019, where the court ruled that public access channels are not state actors, even if highly regulated by the state government. New York state regulations, the public access stations, required that these access channels operate almost like a common carrier. But again, the court treats editorial discretion as a regulatory term conveying the limits to governmental control, but not constituting speech. And now a case that's actually very relevant now, which is Missouri v. Biden, is currently being litigated, and I think it's extremely relevant, and we'll talk about it at a little more depth, but I want to give us a segue into it by providing a little bit of context to an issue that may be relevant to us. So this is about a story given by Phil Williams at News Channel 5 Investigates. And this is about a mayoral candidate, Gabrielle Hanson from Franklin, Tennessee, who was running for mayor and posted on her social media a photo of her and alleged supporters. But come to find out, the people in that photo didn't even know who she was, and they weren't there in support of her. They were there for like an advertising campaign that really had nothing to do with her mayoral campaign. And so we have a video here from the journalist to give you a little insight about that situation.
Something else today, so I have no idea what you're doing.
Well, if you look at what I texted you this morning, I said in there that I had spoken to the women who were in the photo that you have posted on social media, and they say that you have lifted that photo, that you are misrepresenting that photo, that they are not supporting you, that they don't live in Tennessee as you claim.
Yeah, they live all over the country, and we get together very regularly for all sorts of support for each other.
Phil, on Missouri versus Biden, which was just came out in the news, you are allowed to say exactly what you want on social media. And this was
Who is this saying that?
this is Aaron Mazzoni, the campaign director. So are you saying that we're not allowed to post what we would like to post personally?
Are you saying you can post lies?
No, I'm asking you, are we not allowed as a person, do we not have a constitutional First Amendment right? I'm asking you.
Well, I'm asking Gabrielle why she's posting something that's not true.
And it is true, and one of them was calling you all morning, and you wouldn't take her call.
That's
Yes.
that is not true. Who was that?
Yes, it is true. I can send you the screenshot of all her calls to you.
Listen, this is the basic thing. We just moved from the north. This is exactly what the left does. You take everything, you twist it, you turn it. You're told by the left to come after us, and that is exactly what you're doing. And if you go look at the law, we have something called constitutional rights where we are allowed to post whatever we would like to post on our social media, period.
Okay, may I record this for broadcast?
No, you can't do anything because you're going to take it and twist it and probably edit it and say horrible things, which is exactly what you're trying to do right now. You won't even answer my question about Missouri versus Biden, which every reporter should know. And by the way, journalists, if you're going to do this with us on every single thing, I don't understand. Is she not allowed to post when she goes out with friends? Are you going to be following her around? Do we have to ensure that this is is this going to be a safety situation where you're going to be following her?
And stalking everybody?
Yes, this is not appropriate towards a woman, though. This is not appropriate.
When was that photo taken?
I don't even know. I think we had posted a whole barrage of photos whenever we had gone out, but we don't even know what you're talking about. We have tons of photos, just like Mayor Moore has 13 years of photos that he has taken. Did you go and look at every single photo and call every single person that was with him?
Okay,
I would like to know.
Your story is not consistent. You're just telling me you know
Sir,
which.
we're not talking. This is not a story. If this is all you have about an Instagram post with a picture, then I would like for you to please come back and ask us, because this needs to be a conversation, not you coming after us about a post. And if you would like to do some research on Mayor Moore and call every person with every single photo that he has uploaded, please let me know once you've done that.
So I want to take a moment to unpack what we just heard here. And so I want us to think about this in the context of Gabrielle Hanson actually being the mayor and not a mayoral candidate, because this gives us more of an insight into what editorial discretion means and being refrained by a government official in our speech and our publications. So some of the major points that we get from that video in the context of editorial discretion is forcing speech, restricting speech, and dictating the newsworthiness or legitimacy of news coverage. And so for the first one, you heard that quote, if you'd like to do some research on Mayor Moore, who was the opposing political candidate, and call every person and every single photo he has uploaded, please let me know when you do that, right? And so this is an example of, in the context of this person being a mayor, someone trying to force you to go and, secure news on someone else, another candidate, and then post that. So forcing speech. And then you have this quote, if this is all you have, an Instagram post, go back and do your research, essentially condemning the publishing of or covering of that type of media and content. And then lastly, the dictating the newsworthiness and legitimacy of an issue, just flat out saying, this is not a story, this is not newsworthy. That's an example of, a political candidate trying to dictate your speech, which is something that would be a violation of your editorial discretion. And so we get this quote in the video. Are you saying we don't have a constitutional First Amendment right to post what we'd like? And I want to talk about that because that leads us into an analysis of that case, Missouri v. Biden, that was mentioned very heavily in the beginning of that video and also talked about in the beginning of this presentation about being a very fundamental case. So in Missouri v. Biden, 3 doctors, a news website, a healthcare activist, and 2 states sued the Biden administration officials and several federal agencies, alleging that communications between the government and major platforms like Facebook and Twitter concerning their moderation of several topics at the time, which was related to the pandemic, violated their First Amendment rights. And so this is what we consider to be an example of jawboning, which is a term that describes informal efforts by government officials to persuade or pressure private entities, in this case related to speech, to adhere to governmental requests. And so jawboning sometimes carries with it an express or implied threat of regulation or adverse consequences if entities don't adhere to governmental requests. So a little bit more about that case, some of the legal concepts that are considered in Missouri v. Biden. I'm sure we can all agree that at some point we've been on social media and we've seen something and wondered, should we actually be seeing this? Maybe it felt like it was misinformation. Maybe it felt like it was harmful or inappropriate to see. And I think this case really brings up the important issue in that debate. And it tries to draw a line between the government stepping in to inform or reinforce safety and violating the First Amendment. And so more explicitly, the question is, do social media companies have their own free speech rights? And what happens when the government tries to censor them? And so the courts in Missouri v. Biden have relied heavily on the Batnum Books v. Sullivan case, in which we get this test almost of distinguishing between coercion and persuasion. And coercion would be an example of a violation of your editorial discretion because the government is essentially forcing you to publish or post in a certain way. And so first, we consider the government's official word choice and tone. We consider the recipient's perception. We consider whether the official has regulatory authority. And then we consider whether the speaker refers to adverse consequences like litigation. Okay. And so another fundamental concept in Missouri v. Biden is the concept of significant encouragement. And so courts relied heavily upon the significant encouragement theory and found that if a government's encouragement is so significant that we should attribute the private party's choice to the state, then that would be coercive. Further, any oral or written statements made by a public official that could give rise to a valid First Amendment claim where the comments of the government official can reasonably be interpreted as some form of punishment or adverse regulatory action would follow as being coercive and significant encouragement. Okay. And so this leads us into a discussion of another relevant law regarding speech online and social media. And so some have argued that the birth of the internet foreshadowed the death of censorship, but that isn't necessarily the case. And censorship is being used by the government in an intimidating manner against social media, print media, and in the flow of online information. And so social media platforms are private companies, and they're legally able to establish regulations and guidelines within their community, establishing censorship and content or banning members. So although laws and regulations like this protect the service and not necessarily the user, if the Biden administration prevails in Missouri v. Biden, we begin to see a chipping away of laws like this. And I think it's important to sort of note how this kind of law and this kind of legal framework is integral and almost synonymous to newsworthiness and publishing and journalists. And so in the way that we see social media platforms advocating for their right to free speech, journalist platforms and broadcasting platforms also are sort of doing that in a similar way against violations against their editorial discretion. Okay. And so that brings us to another set of cases, NetChoice v. Paxton and Moody v. NetChoice, which are also very important cases regarding social media and speech laws. And perhaps the most important question posed by the recent First Amendment challenges to the Florida and Texas laws regarding social media is whether platforms exercise a constitutionally protected right to editorial discretion when they moderate speech. And the platform's central challenge to both laws is that their must-carry and transparency obligations infringe on the right by interfering with the platform's ability to pick and choose which speech they host on their sites. It's the same right, they argue, that newspapers exercise when they pick and choose which speech appears on their pages. And these cases have the potential to reshape First Amendment rights online, but they could also impact First Amendment rights of journalists and news organizations by teeing up the court to reconsider fundamental First Amendment protections for the press. So I want to talk briefly about that legislative process in these cases because we have a circuit split, which is where the courts are sort of disagreeing on fundamental issues in this case. And so the question is, do social media sites have the First Amendment right to choose which information they publish on their websites? And so the Fifth Circuit rejected the Tornello argument, and we discussed Tornello earlier, and upheld that the Texas law prohibiting platforms from removing content-based posters' viewpoints was okay. And then we hear from the 11th Circuit, where the 11th Circuit struck down a similar Florida law and agreed that the platform's content moderation decisions are constitutionally protected exercises of editorial judgment. Now, how will these kinds of cases affect you and your rights as a journalist? So there's no question that platform content moderation works differently than the editorial process that newspaper and other media organizations employ, but these differences reflect the fact that platforms play a different role in the public sphere. Regardless, the ultimate point is that the protection of editorial discretion requires protection of reporters, broadcasters, social media platforms, journalists, and so many others, fundamental freedom of speech because of what the process contributes to the democratic discourse. And the facts are integral. These facts are integral to the judicial analysis of the form and extent of platforms' editorial discretion. So I want to briefly talk about some legal remedies that you may have or non-legal remedies that you may have if you feel like your right to editorial discretion has been violated. So some legal remedies may include litigation, a written complaint, a settlement, seeking damages or an injunction, which is court-ordered performance. And non-legal remedies could be conversations, mediation, petitions or protests using your social media platforms for advocacy or press and media campaigns. Okay, and so this is a little bit of an interactive exercise. So I ask if you feel so inclined and you want to hop in and engage in conversation, please feel free to do so. So in law school, we use a lot of hypotheticals to understand some of the legal nuances that apply to our day-to-day issues. And so I want to do that here by bringing in an interactive hypothetical for us to consider how editorial discretion may apply to our own lives. Okay, so the hypothetical scenario is Bo Hayden, a local governor, urges the leading news outlet, The Beacon, to publish an op-ed supporting their campaign. They argue that this will counter what they perceive as biased coverage favoring their opponent, Ronald Gump. And if The Beacon does not post this article, then Hayden has threatened to sue the news outlet for defamation. In your opinion, is this an infringement of your editorial discretion? If so, where would it fall on the spectrum? Do we have any brave souls who want to give their opinion? Feel free to hop in. Don't leave me hanging. Okay. What do you think?
Sounds like an infringement
Okay. Why do you think that?
because the government's threatening you to publish something even though it might not be your view or you want to publish.
Okay. Does anybody agree, disagree with that? Maybe have a story that they feel inclined to share about an instance of something similar? All right. Okay. So that leads us into our next topic of prior restraint. So prior restraint is any government rule or regulation that limits speech or publication in advance of when the speech or publication is supposed to occur. And so in a very foundational case, we get the Pentagon Papers case, which is an instance where the New York Times in June of 1971 began publishing classified and top secret information known as the Pentagon Papers related to American policies and activities going on in the Vietnam War, which were copied from the State Department and the Department of Defense. And so at that time, the Department of Justice filed a restraining order due to a national security threat, but the Supreme Court found that to be unconstitutional. And so this case really lays the foundation for the heightened scrutiny that the courts give in regards to prior restraints, and how even though there was a claim that publishing these papers could be harmful to our nation and our democracy, the court still allowed these journalists to move forward with publishing their content. Okay. And then we have the Nebraska Press Association v. Stewart case. And so here the court addressed the constitutionality of an order prohibiting the media from publishing and broadcasting certain information about Erwin Charles, who was accused of murdering a family in Nebraska. Excuse me. Okay. And so Chief Justice Berger reasoned that a whole community cannot be restrained from discussing a subject intimately affecting life within it. So essentially we get this ruling that if something is so integral to our community and to our nation, then journalists should not be forbidden from publishing about it and talking about it and sharing and disseminating that information with the public. So what's the law that we get from that case? So we get that to establish a valid prior restraint under the Constitution, the government has a heavy burden to show the interest is compelling, the prior restraint is necessary, and would be effective in promoting this interest unless extreme measures are unavailable. And so I want to talk about that a little bit more in this next slide, what the court's considerations were when coming to that ruling in that case. So the court considers the nature and extent of pretrial news coverage. They consider whether there are any less restrictive means, and they consider the effectiveness of a restraining order and preventing that threatened danger. Okay, and so that leads us to a case that's a little bit closer to home here, Toledo Blade Company v. Henry City Court of Common Pleas. And so in this case, the Ohio Supreme Court reversed the trial court's order that prohibited the media from reporting on one defendant's criminal trial until after the impaneling of a jury in a second defendant's criminal trial. And the trial court had justified its order on the grounds that the publicity was likely to prejudice the second defendant's right to a fair trial. And so in reversing the trial court's order, the Ohio Supreme Court relied very heavily on that Nebraska Press Association's case to conclude that the trial court's order was unconstitutional. So let's talk about what to do if ordered not to publish something. So what to do if you're in a situation of prior restraint. So if an individual requests that you not publish certain information, first you should try to determine the motivation for it. For example, is an individual unduly sensitive to what they think you might publish? Do they think that it might cause some sort of harm? And then if you're threatened with prosecution under a statute that supposedly makes the publication of the information a crime, ask to see that statute or get enough information so that you can obtain a copy of it for yourself. And if such law exists and covers the kind of information that you want to publish, then you should consider consulting an attorney about the constitutionality of that law before moving forward. And finally, if a judge orders you not to publish, then you should obviously take that order very seriously. You should ask for a copy of the order and consult with your editors immediately. And as always, you can feel free to talk to us at the First Amendment Clinic or the Reporters Committee for assistance in finding an attorney if you do not have one and you're looking for one in a situation like this. Okay, so what can you do if ordered not to publish? These are some options available to you. So first, you can obey the order, but you might not want to do that. So you can then either obey the order while considering a constitutional challenge, secure a lawyer, consider some of the constitutional issues that are underpinning that challenge. And then remember that you don't have to deal with these kinds of issues alone. There are lawyers and legal clinics like ourselves that dedicate their work to advocating for you in instances like this. So if you hit a wall and feel like you need assistance, then remember that you can always contact a lawyer. All right, so I want to move into my last point here, which is about gag orders. And so gag orders are a form of prior restraint that prohibit parties, lawyers, prosecutors, witnesses, law enforcement officials, jurors, and even others from talking to the press. And so judges often call gag orders protective orders and say that they are necessary to protect a person's right to a fair trial. But regardless of what judges call them or who initiates them, a gag order interferes with your efforts or can interfere with your efforts to gather and disseminate news. Okay, so I want to talk about the Beaufort County Board of Education v. Beaufort County Board of Commissioners case. And so this is a case where a local school board sued the county commissioners for underfunding their board. And the trial court ordered that these parties and their counsel cannot communicate with the news media about this litigation. The court in that case ruled that a gag order on trial participants is a prior restraint on free speech and presumptively unconstitutional. And the validity of a gag order may continue to be challenged after it's dissolved if the exception to the dismissal for mootness applies. And let's talk about why that is here in the next slide. So what does the court have to prove in order to enforce a gag order? So the first is they must prove that there is a clear threat to the fairness of trial. They must prove that the threat is posed by the actual publicity to be restrained. And they must prove that there are no less restrictive alternatives to the gag orders that are available. And we see this similar thinking as we discussed in Missouri v. Biden and other cases that we mentioned earlier. So we know that this is something that's very important in the court's considerations. Okay. So what can you do if a court issues a gag order? First, you want to get a copy of that order. You should be able to get a copy from a court clerk. And then you want to find out who the gag order restricts, and what the judge's justifications for issuing that gag order might be. So nuances in the language of an order may greatly affect whether it will be upheld on appeal. Now, if your sources have been gagged, then you might need advice on whether you can challenge the order or whether the person directly affected must bring a challenge to that order. And here too, you may also want to consider legal counsel, because those types of issues and concepts can get a little tricky and complex. But in some cases, a judge might lift or modify a gag order when told of the constitutional issues that they pose. So these things can sometimes be a slippery slope, which is why it's important to rely on attorneys or legal advice that you may gain to understand the constitutionality of issues like this. All right, so that is all that I have. I want to say thank you for listening, and if you think you have a matter that this clinic may be able to help you with, then please feel free to email us at lawclinic@case.edu. But thank you so much.
Good morning, everyone. My name is Siobhan. I'm a fellow with the Law Clinic. Thank you all for being here this morning. Thank you to NACA for a great presentation. I'm pleased to present our next certified legal intern, Hannah Cyphers. She will be presenting about First Amendment law in the special context of schools.
Good morning, everyone. Okay, as Siobhan said, good morning. My name is Hannah Cyphers, and today I'm going to be talking about student speech in general, and then also diving in a little more onto student journalism and your rights around that, since I know we have some student journalists in the room. So to start off, I just want to talk about a few Supreme Court cases that really established students' First Amendment rights. The first case I want to talk about is Tinker v. Des Moines, and this was a case that began in Iowa. This was in the 1960s, and a few students in the high school and some in the middle school there wanted to wear black armbands to school to protest the Vietnam War. The school administration heard about this plan and reached out to the students, told them, don't wear the black armbands. If you do, there's going to be some sort of disciplinary action. But the students ended up wearing them anyway, and they ultimately were suspended. But they ended up bringing this case, Tinker v. Des Moines. You can see some of the students from back in the day in the top picture, and then there they are pictured today, the bottom. So this case, like I said, went all the way to the Supreme Court. The question was the school justified, or did they have the right to discipline these students for wearing their black armbands and protesting? And the Supreme Court ultimately came down in favor of these students. So this was a monumental case for student speech rights. The court said that students retain their First Amendment rights at schools, so they still are allowed to say what they want to say, but there are some restrictions. So the first one is that speech that causes a material disruption or involves substantial disorder, like disrupting classwork, is not protected by the First Amendment. So if the students had like a bigger protest that took away from class time, then the Supreme Court probably would have come down in favor of the schools and said that the schools were justified in disciplining the students. But in Tinker, I mean, they were just wearing armbands. It wasn't taking away from class time. It wasn't taking away from academics. So there was no like material disruption that justified the school disciplining the students. The next case I want to talk about is Bethel v. Frazier. So this was a case where the student pictured here was running for student government, and he got up in front of a school assembly and made a bunch of lewd and kind of offensive, sometimes sexually charged comments about his opposing candidate. the school was obviously unhappy with this and suspended him. And then he brought this case challenging whether he should have been suspended. So this case also went all the way up to the Supreme Court of the United States, and they ultimately ruled that the school district was justified in punishing this student, stating that schools may discipline students for vulgar or offensive language. So the Supreme Court kind of relied on the idea that schools have an interest in protecting students from anything that's socially inappropriate during school hours. And in making the decision here, the Supreme Court considered the maturity of the audience. So there were some students who were as young as 14 who were hearing this. And they said the speech in question was plainly offensive both to students and to teachers, especially considering the kids were as young as 14, some of them. So main takeaway from this case, it did kind of narrow what was originally said in Tinker. Schools can regulate student speech that is plainly offensive, and they're going to take into account the maturity level of the audience. One more court case, or Supreme Court case I want to talk about is Morse v. Frederick. And this was a case in Alaska where I think they were high school students went on a school-sponsored field trip. They took this banner that says "Bong Hits for Jesus," and they unfurled it at this parade that the students were attending. And the students were suspended, no surprise. So this case also went all the way up to the Supreme Court, and the court here ruled in favor of the school and said that schools may censor student speech related to legitimate educational concerns or legitimate pedagogical concerns, which here the concern was illegal drug use. The school had an interest in not promoting illegal drug use or looking like it condoned illegal drug use. So again, this was kind of a narrowing of what happened in Tinker. The last Supreme Court case I want to talk about is Hazelwood. And this case involved a student newspaper, so maybe relevant to some of you. The student newspaper wanted to publish a couple articles, one about teen pregnancy and some students in their class who had gotten pregnant, and another article about students whose parents were getting divorced. The principal learned about these potential articles and said the school was not allowed to, or the newspaper was not allowed to publish them because it violated students' privacy rights and potentially could also violate some of the parents' privacy rights if they were the ones getting divorced. This case, again, went to the Supreme Court, and in deciding the case, the court highlighted that the student newspaper was part of a journalism course. So this wasn't some sort of extracurricular activity that was being done not during school hours, but like before or after school. The students in question were actually getting credit and receiving grades for their participation in this course. And that's really key because schools are, the rule that kind of came down from this is that schools may only censor speech related to legitimate pedagogical concerns, which is essentially like an educational concern, which we kind of talked about earlier in the Bong Hits for Jesus case. So here the court said that the educational concerns in question, so a reason that a court could, or a school could censor a student newspaper would be articles that are ungrammatical, poorly written, inadequately researched, biased or prejudiced, vulgar or profane, or unsuitable for immature audiences. Sorry, just 1 second. So this case essentially, ultimately the court said the school was justified in deleting the student articles because schools may refuse to sponsor any student speech that's perceived to advocate for like drug or alcohol abuse, irresponsible sex, or conduct that is otherwise inconsistent with the values of a shared civilized order. So boiling all of that down, anything that a school could think is like inappropriate, they might be able to censor. The court also said, though, that the school has authority to regulate other expressive activities. So I talked about how these students were part of a journalism course, but schools also have the ability to regulate some extracurricular activities, like maybe theater productions, that students, parents, or members of the public might reasonably perceive to bear the endorsement or like the approval of the school. So again, if a school was trying to put on a production that involved like illegal drug use or advocated for irresponsible sex, the school might be able to censor that. However, if these kinds of activities are supervised by faculty members and designed to teach students particular skills, then educators have greater control over student speech with these activities. So, boiling all of this down, Hazelwood kind of muddied the waters for what student speech is permissible and what is not permissible. A lot of free speech and First Amendment advocates don't really like the Hazelwood case, because it made things a lot more confusing. They came out with this, legitimate educational concerns standard, but that's pretty hard to define. So this case did unfortunately take some power away from students and kind of gave it back to the schools and gave the schools more discretion. Okay, so everything I have covered so far just applies to public schools. So just to reiterate about the First Amendment only protects individuals' speech from government actors censoring that speech. So that would include like a public school teacher or a public school administration. But if you are at a private school, there are still options for you if your speech is being censored. So if you want to pursue some sort of legal remedy, you might be able to rely on contract law. So essentially, by paying for your tuition at a private school, you are establishing a contractual relationship with that private school. This means the school is essentially legally required to abide by its established guidelines, adhere to its handbook, that sort of thing. And if the school doesn't abide by its own rules, then the school breaches its contract with students, and the students could sue to obtain legal relief. This applies to speech specifically because a lot of schools, and especially universities, have some sort of policy around student free speech and student expression. Also, if a student is punished for their speech, you might be able to look at the disciplinary process or stated disciplinary process in the school handbook and see if the school is adequately adhering to its standards there. And if they're not, that's another option where you may be able to sue. So student journalists at private universities could also potentially rely on their contractual rights with their faculty advisors. So faculty typically have some sort of provision in their contract about academic freedom, which means that they are allowed to teach their students what they think is appropriate. So basically, to boil all of this down, if you are at a private school, try to be familiar with your handbook. Just generally try to be familiar with what the handbook says is permissible and what isn't. And then if you think your school has violated any of the things stated in the handbook, you might want to reach out to a lawyer and get legal advice. And then lastly, for private schools, regardless of whether there is a contractual relationship and you can rely on contract law, some courts have said that if private schools take enough federal funding from the government, then they essentially are also bound by the Constitution and by the First Amendment. This is called like state action, or the school would be considered a government actor, even though they aren't like technically part of the government. This, again, you might be able to rely on this. It really depends on which district in the United States you're in. Some courts say if you take federal funding, then you have to like abide by the Constitution, but some courts have a more rigorous standard when kind of analyzing that sort of thing. So that's kind of just laying the groundwork for First Amendment speech for students in general. Now I want to turn to student journalism. So I have a couple headlines here that I think are all from the past year or two. The first one is about a case filed by the ACLU on behalf of a former student in Nebraska against the school district because the school district tried to prevent this student from covering LGBTQIA issues in the student newspaper. That middle headline is about a student at Tufts University, and she was sued after she covered a local protest and tried to publish it in her school newspaper. And then the last headline is about a charter school and censoring a student newspaper about writing an article about the school library closing down and kind of criticizing that decision. So based on these examples, you can see that censorship of student journalists is very timely. Unfortunately, it's happening all around the country every day. Student journalists have a lot of power, as I'm sure you all know, just because they have so much more access than the public to administrators and school decisions and that sort of thing. And of course, administrators don't always want what's going on in the school to be publicized to the rest of the town or country or whatever. One more student journalism example. This actually happened in the Cleveland suburb of Shaker Heights. So the student newspaper there, the Shakerite, wrote this article, I think in March, and it was criticizing the district's decision to integrate core level classes with honors level classes. It was called detracking. And it was a really well-written article for high school students. It included a lot of quotes from teachers, from students who were critical of the decision, and it also expressed or had some quotes from Dr. David Glassner, who is the superintendent of this school district, and this was kind of his pet project, this integrating the classes. So it had some criticism of Dr. Glassner in the article as well. And then in response, Dr. Glassner wrote a letter to the editor of the Shakerite calling the original article unfair and unbalanced and challenging the students to engage in balanced reflection. So he wasn't outright censoring the students and saying, oh, you can't publish this article that criticizes me, but he wrote this letter in response, which could be seen as having a sort of chilling effect on the student journalists. You know, they published this article criticizing him now, but maybe they'll be less likely to criticize him in the future, which again is what we call a chilling effect. So next I want to walk you through what would happen if you were at a school and you're a student journalist and the school is trying to prevent you from publishing an article. So this is kind of legal and technical, but I'm going to try to break it down. And this is essentially how a court would walk through this decision. And also keep in mind that this applies to public schools primarily, might apply to private schools depending on what I talked about earlier. So the first thing a court needs to determine is what kind of forum the student newspaper is. So there are a few different kinds of forums that you'll hear about in First Amendment cases, like a public forum, limited public forum, non-public forum, and they all have different levels of permissible speech, or essentially the government can regulate speech to differing degrees depending on what kind of forum it is. So for instance, in a limited public forum, schools could limit certain topics as long as the school's discrimination is viewpoint neutral and related to an educational concern. So this kind of goes back to what we talked about earlier. If a student article causes a material disruption in school or is age inappropriate for the maturity level of the audience, this could be considered an educational concern, and schools could be able to censor this in a limited public forum. So, what exactly is a limited public forum? I have some factors listed here, and I think most of these come from the Hazelwood case I talked about earlier. If a student newspaper in question meets most or all of these factors, a court is more likely to say it's not a limited public forum, but it's actually a non-public forum. And in non-public forums, school administrators can exercise more restrictions on student speech than in a limited public forum. So to boil all this down, essentially, the more a student newspaper resembles an extracurricular activity rather than like a journalism course, the more likely a court is to consider it a limited public forum. So the more control the school exercises on the front end, the more that school is able to regulate what is published and, if they choose to censor something. And an important distinction to make here is that most of these factors are more likely to apply to high school journalists, and college publications have a lot more leeway and a lot more freedom to publish what they want. Here are some other examples of educational concerns, which again are, a school could argue if they're trying to get something from being published that there's an educational concern. They might say, oh, you can't publish this because it violates student privacy, or it's inappropriate for the intended audience, or it doesn't apply or adhere to journalistic standards, isn't fair, isn't balanced, that sort of thing. So these are all, These are all things that a court would look at and see, does the stated reason that the school is giving for the educational concern match the actual reason that the school is trying to censor this? Okay. But remember, even if there is an educational concern, restrictions on speech have to be viewpoint neutral. So, of course, schools are always going to argue that they're being viewpoint neutral, but this is probably not the case, or may not always be the case. So you might want to look into whether student speech has ever been censored in the past and what the stated reasoning of the school was then to determine if the school is being viewpoint neutral. An example of this would be if a school prohibited students from publishing articles about Democratic candidates, but allowed students to publish about Republican candidates. So it's probably not going to be, that's an example of something not being viewpoint neutral because the school is clearly taking a side. It's probably not going to be this cut and dry if you are ever faced with this situation, but I'd encourage you to look into what kind of speech has historically been allowed on your campus and what has historically not been allowed to determine if the school is being viewpoint neutral. And like I said earlier, the school might give a stated reason for why they want to censor the speech, but you might want to do some digging and try to figure out what is their actual reason for wanting to censor this speech. And this whole analysis is very fact specific, so it's also, this could be a time when you might want to pull in a legal advisor or get advice from an attorney. So this is a flow chart. It might be kind of hard to see, but you can maybe take a picture of it. This is from the Student Press Law Center, and this basically boils down everything I covered in the past few slides. Also, just quick plug for the Student Press Law Center. They have a ton of resources for students, for faculty, for school admin, student journalists specifically, about student speech rights. So I would say that's probably your first line of defense. If you feel like you're being censored at school for your speech, I would go to the Student Press Law Center and take a look at their website and see if they have something that is, if they have an example that's kind of related to your situation. Next, I want to cover off-campus student speech. So historically, what was said on campus and what was said off campus by students was very distinct. There was like a clear line. But with social media and the internet, it's a lot easier for for students to talk about their school when they're not necessarily on campus. So one more Supreme Court case I wanted to discuss was a 2020 case called Mahanoy. And this was a situation, maybe some of you have heard of it, when this young woman here, she tried out for the varsity cheerleading team. She didn't make the varsity cheerleading team, she made JV, and she was upset about it. So she posted something on her Snapchat story when she was off campus. It was during the weekend, not on school grounds. She posted a story that was captioned, "Fuck school, fuck softball, fuck cheer, fuck everything," just as kind of a way to, I guess, air her grievances. And even though this wasn't on school property, some students from her class saw her post and they reported her to the administration. And she was actually suspended from being even on the junior varsity cheerleading team. So she filed suit, and this case went all the way to the Supreme Court. The court said that public schools do have a special interest in regulating off-campus student speech, but really only in situations where a student is being bullied or harassed. So this case may have come out a little differently if the student had said, you know, fuck so-and-so student, rather than just like fuck softball. Because that could be seen as like bullying, and the school has an interest in not allowing students to get bullied or harassed. So schools are allowed to regulate, well, essentially the court's reasoning here was, if schools could regulate off-student speech, then students essentially don't have First Amendment rights anymore, which is not something the court wants to promote. So in the end, the court held that the school lacked authority to regulate this student's speech and should not have disciplined her by suspending her from cheerleading, and essentially because this speech didn't cause a material disruption. People in school were talking about it, but it wasn't taking away from any actual learning that was happening at school. It wasn't taking away class time. So she shouldn't have faced disciplinary action. And then the last thing I want to cover is yearbooks. So if anybody was on student yearbook in high school, you know that yearbooks can be a big point of contention between students and between school administrators. So two main takeaways here. First one is that school administrators cannot force you to publish any certain photo or any certain quote that they want in the yearbook. So the same way that the First Amendment protects speech that you do say, it also protects your right not to speak. The only way a school could maybe get around this is if you blatantly left out like the entire freshman class. Then the school could say, okay, you need to include the freshmen. But other than that, they generally cannot say you have to include this picture of the principal or this quote from the superintendent. The other key takeaway here, and this is related to senior quotes, which I have some examples of here. I'm sure we all know that it's kind of common practice for high schoolers to have senior quotes that might be political, have some sort of like sexual innuendo or reference to illegal drugs. And there hasn't been a Supreme Court case directly dealing with student yearbook quotes and what is allowed and what isn't, but it's likely that if a school tried to say you couldn't have a certain yearbook quote, that would only be, they could only keep you from having that quote if the quote caused, again, a material disruption in the school. So that kind of goes back to the educational concern I mentioned earlier. And with that, I just wanted to give one more quick plug for the Student Press Law Center. Again, they have a ton of resources. I relied heavily on them for this presentation. And then, as always, you're welcome to reach out to the First Amendment Clinic at Case. We're happy to help if you ever feel like you're being censored or need any certain advice. So with that, I will open it up if there are any questions. Yes?
How does the law address student journalists who are interns for an existing population?
Oh, so they're, like if you had an intern at the Indy, I think it would depend on if the school, or it would highly depend on if the school was giving that student credit for their internship. If they were just doing an internship in the summer, they weren't getting class credit for it, I think they would have more rights to say whatever they wanted. And I think the fact that if you had an intern at the Indy, for example, they're probably not going to be, the school is not going to have a lot of control over what is said there because the Indy is totally separate from the school. So I would say in that situation, they're probably going to be treated more just like an employee rather than like a student, like representative of the school or like a student journalist, if that answers your question.
Particularly if that intern were reporting on their school.
Mm.
So if we assigned an intern to do a story about conditions in the dorm.
That's a good question. And I don't totally know. Again, I think it would depend on how much control the Athens Indy is exercising over that article, which would probably be like all of the control. The school doesn't have any say about it. So I would doubt that the school would be able to discipline that student or come after the Athens Indy in any way. Again, also caveat, all of this is very fact dependent, and the law is kind of changing every day. So if there are any like very specific examples, I'd encourage you to seek legal advice. Any other questions? Okay, thank you guys.
Thank you so much, Hannah. That was great. Our next presenter, and this will be our last presenter before we take a quick break and before we have lunch, but our presenter will be Patrick Elliott. He'll be speaking about the First Amendment right of access to courts and court documents.
Good morning. Is that working? Great. Okay, so Patrick Elliott, certified legal intern, not a lawyer. Just keep that in mind. Anything I say is not binding. You can't take me to court, or I guess you could. I don't know. Anyway, so I just want to get a gauge of the room. Students, journalists, student journalists. Okay, great. Good. Just so I know what I'm working with. Okay. So my topic is court access. So, this is about, can you go to a court hearing? Can you get documents from a court hearing? Can you get documents from a court? Those sorts of things. If you're out and reporting on certain issues, especially about trials, those can be very public and very popular. People want to know about them if they're high profile. So this can be very important if you want documents from the trial, or if you just want to sit in on what might be happening in the court. So it starts from the First Amendment. So there's a Rockwell painting to basically gauge your interest. So hopefully everyone's seen this at least once in their life, learned about it in school, and it's something that we've talked about a lot this semester, being in the First Amendment clinic, as you might anticipate. But what's important for our purposes, or for my purposes here today, is about the free speech clause and the free press clause. So there is a free speech right, and that gets attached to court hearings. So your right to sit in on a court hearing and your right to access those documents comes from your First Amendment rights to speech and to the press. And like I said, when it comes to the press and when we're applying that to journalists, that also will apply to courts and basically says that you have a right to these hearings and you have a right to these documents. And that is understood as a baseline right. So the presumption going in is that you have an access to these things. So if the court wants to say, you can't have this, I'm not going to let you in and watch this trial, you can't have this, document, whatever it was we were talking about today, they have to be the ones to prove their case against you. So keep that in mind as we go through all this. And if you take anything away from what I tell you, just remember that the baseline right is that you have the right, not the court, to keep you out. And then also in the Ohio Constitution, which I think maybe flies under the radar a little bit, especially when we're talking about these sorts of things, the Ohio Constitution also guarantees you certain rights. And they actually go further than the First Amendment with their, when they talk about courts, which is they actually have an open courts clause. So it's in Article 6 or Section 16, Article 1 of the Ohio Constitution, and says all courts shall be open, every person, injury done in lands, goods, person, very old-fashioned language. It's a very old document. But this is something that's still applied today. It comes up anytime a journalist says they want access to these sorts of things. If the court's not starting here, they're doing something wrong. So, another baseline principle. Anyone know this gentleman? His name's up there. So, it's Justice Brandeis. So he was Supreme Court Justice about, give or take, 100 years ago. And he had this quote basically saying, sunlight is the best disinfectant. I thought this was from a court opinion or dissent. It actually wasn't. He wrote it in a book. But if you read a lot of court cases about this sorts of issues, which I have, you'll see this quote a lot. And it basically is just him saying the best way to make sure that the court is not doing something that we don't want it to do, or to make sure that there's no corruption or whatever going on, is basically to shed light on what it is they're doing. So I think a lot of these principles come from this idea that the public has a right to know what's going on, and journalists, as the people who are reporting on what the court is doing to the public, you have that right as well to know what they're doing, know what's going on, and to basically convey that information to the public. So before I got into anything about court documents, court access, I thought it'd be nice to go through a basic overview of how courts in this country work, because this is something that I didn't really understand until I got to law school. I knew there were federal courts, I knew there were state courts, and I didn't really know why. But so in Ohio, we have 3 basic courts that before you get to appeals. So municipal courts, there's one in here in Athens County. It's the Athens Municipal Court. That's your small claims. So I think in Ohio it's anything under $15,000. So if you come into my apartment and you break my $100 vase and I sue you, we're going to municipal court. Or traffic tickets, misdemeanors, things like that. That's municipal court. Common pleas is usually felonies. So I was an intern previously with the Cuyahoga County prosecutor, and that was in common pleas, and that's all felony. So, your murders, high profile, if it's raising your eyebrows, it's probably in common pleas court, and anything over 15 grand. So if while you're breaking my vase, you burn the house down, you're probably going to common pleas court if I'm going to sue you for the house. And then court of claims, that would be, actions against state agencies. So if you had a beef with the ODNR, you're probably going to court of claims. And then if you get an outcome there that you don't necessarily like, you're going to the appeals courts. So those are district courts. Athens, I believe, is the 4th district. Yes, good. Okay, I'm from Washington County. So using my geographical expertise to figure out this is the 4th district. And from Cuyahoga County, where we are, that's the 8th district. So I think there's 11 or 12 of those. And then if you don't like that outcome, you're going to the Ohio Supreme Court, which is the highest court in Ohio. It also regulates the practice of law in the state of Ohio, which is what we'll get into later. And in federal courts, it's basically the same idea. You got your district courts, you got your circuit courts. Ohio's in the 6th Circuit, and then you go to the U.S. Supreme Court. So one thing we'll get into also is if you have a First Amendment issue, that's probably going to federal court. It's federal constitution, but it applies federal law. You'll go to federal court, but then if you have a court access issue, that might be Ohio law, so then you'd be in an Ohio court. So sometimes you'll see issues where maybe someone's suing something for one thing. They might be in both state court and federal court. That could be why. Federal courts also can apply state law in some instances, but that's civil procedure, and if you want to learn more about that, you can go to law school with us. So we'll start in federal courts. So this is about hearing access. So this is basically getting back to what I said before, and mostly with these First Amendment rights that you might have when a court is deciding whether or not you get to exercise this right. It's more of a balancing test. So what they're going to do, especially in these instances where there's federal court, is that they're going to balance it against other interests. So usually, and what you'll see in this case in Press Enterprise, it was a federal criminal trial, and you have a Sixth Amendment right to speedy trial, open trial, fair trial. So what the courts get really concerned about is, especially, and I think we've hit on it a lot before, is publicity. So if a journalist is reporting on something and it's getting out to the public, that can taint the jury pool, that can taint all sorts of other things that might be involved with the trial. So sometimes courts will be very quick to say, you can't report on this, prior restraint. You can't do anything related to this because we need to have a fair trial. And then that's where we get down into the weeds and we figure out what exactly is going on, whether or not you have this right. So this is actually a qualified right, which we'll get into later. It's not absolute. But in press enterprise, which is one of the big cases, if you're also wondering what these cases are, the courts don't make law, but they kind of make law. So they'll make decisions based off of laws, and they'll write these opinions, and they'll say, in this instance, closure is essential to preserve higher values and narrowly tailored to serve that interest. So courts basically give guidelines on how to follow the law, and those almost become laws in and of themselves. So if that's something that's been tripping you up, then now you know. But so press enterprise said that you need to make sure that this is narrowly tailored. So what that means, it's a constitutional law principle. It's basically saying that you have to make sure that there's as few restrictions as possible on this closure. So if they wanted to keep you out, it would have to be something as simple as, I don't know, just saying, no, you can't come, and putting somebody at the door. They can't follow you around and make sure you're not coming. They can't, anything like that. And then a few years later, there's another press enterprise case, different controversy, but the same party. So they called it Press Enterprise 2. And it had a lot of the same ideas, but this was more about the right to an open public trial, like I talked about before. And it listed these two factors to make sure that they were balancing correctly the right to a fair trial against journalists' right to go in and report on what was happening. So there had to be a substantial probability that right to fair trial is prejudiced by publicity, like I said before. And you also have to make sure there are reasonable alternatives to the publicity don't exist. So basically saying the only way that the court could prevent this publicity that is so prejudicial is to close or to prevent access. They can't say that has to be the only alternative. There can't be anything else. Otherwise, allowing both interests to go forward, both rights to be exercised, is the best way to proceed. In judicial hearings generally, so this comes from a law treatise. This is something that we read a lot in school. It basically compiles a lot of cases into one place. It states all these things together, so that way we don't have to go looking all over the place. But courts qualified First Amendment-based right of access in criminal cases, rigorous showing required to justify closure. So a qualified right is a right that is not absolute. It means that basically it can be weighed against other rights, like I said before. So courts find rights to fair trials more fundamental. And so if they think that's going to override this right to publicity, then they're going to shut you down. But they have to prove it. Anyone here from Texas? Nobody? Show of hands. I'm not from Texas. Okay. So now I can tell you what I really think about Texas. Anyway, so this is from the Enron scandal, which was one, according to Investopedia, Enron is an energy company that perpetuated one of the biggest accounting frauds in history, and it was a big deal at the time. It was about 20 years ago, and it took down one of the biggest accounting firms in the country, and also took down Enron, which is a big energy company. So this was a case where Skilling, he was one of the executives of Enron, and he had been charged in federal court in Houston, which is where Enron was. And he and his lawyers were very concerned that he wasn't going to get a fair trial, because their logic was, we're in Houston, we're in Texas, this is where Enron was. Everybody here is going to hate me. I'm not going to get a fair jury. And the court went through these 4 factors to basically figure out whether or not they agreed with him, and in the end they didn't. So one of the things they talked about first was the size and characteristics of the community. So what they said was Houston is just huge, just tons of people in Houston, millions. So the odds of them being able to go in and not find 12 people to sit on a jury who were not biased towards this guy, it's minimal to the point of not being a problem. If you were in a place like Nelsonville, maybe, or you could go even smaller than that around here. Some of these towns in Ohio, Southeast Ohio, 50, 60 people. If there's a crime committed there and it's high profile, you might run into some more problems if you're trying to find a jury of 12 people to sit and hear this guy's case, because you're probably going to know the person. But in Houston, that's not a problem. And then you can read the second and third points. But the fourth point, when I hit on there, they said it'd be odd for an appellate court to presume prejudice by any jury that acquits an accused of crimes. So how the appellate process works, he had been convicted already, and he had appealed to an appeals court. And one of the things that the Supreme Court took into consideration was they had not convicted him of all his charges. They had acquitted him of some of his charges. So they said, if this jury really hated you, they're probably not going to acquit you of half your fraud charges, because a lot of people were really mad at Enron. So they acquitted him on some charges. So that's basically some of the factors that you would have to go through to make sure, if you're a judge, to see whether or not there's pretrial publicity, and these are some of the factors that they consider. Prior restraints, which we talked about earlier, I'll just hit it briefly. It kind of ties into this idea of court hearings and court access, because, kind of not letting you in or kind of not letting you see what's going on can be a prior restraint in and of itself, because in some way they're trying to stop you from reporting on what they're doing. And judges sometimes will try to do that a lot. They'll say, I want to be able to do my job, I want to be able to do this, blah, blah, blah. You can't report. So that comes in handy, especially in this area. And something they also talked about in the WikiLeaks case, if you guys remember when that was going on around 15 years ago, the internet has made enforcing prior restraints almost impossible. Because what WikiLeaks would do, they'd get something, they put it on the website, and then everybody was grabbing it. And then somebody sued them saying, you guys need to make them take this down. And the court's like, what do you want us to do? Everybody's already got it. So that's something that I think is also beneficial for journalists. Now there's so much access and everybody knows what's going on at all times. I think that's helpful. So getting into court documents, it's basically the same idea. It's a balancing test, whether or not you have a right to these documents, whether or not, there's prejudice against somebody potentially that would come in if you want to restrict access to documents. Courts have found a First Amendment right to these. They've also found a common law right, which is case law, like I talked about before. Pretrial proceedings, which is things like jury selection, discovery, even some instances, which I'll get into later, if you're trying to disqualify a judge, if you're trying to disqualify an attorney, those are all treated basically the same. There's a First Amendment right to everything that's going on in courts. They don't like to distinguish between them. Like I said, common law right of access to most pretrial documents. So common law, it dates back to basically as long as courts have been operating in this country, sometimes even further than that. Some courts like to adopt common law from England. And they all have basically said the same thing throughout history, which is that these are public, you have a right to them. But one of the places where they kind of tend to get away from that, grand juries, not necessarily as open. Really, the closer you get to judicial decision making, sometimes the more open it's going to be, the less open it's going to be. So, and, parties seeking to steal documents, this comes from the Associated Press case that was here. And secrecy is strictly and inescapably necessary in order to protect a fair trial guarantee. So, all these cases, they have different facts, but it's more or less the same. They're doing the same sort of balancing every single time, and like we've said on all these issues, it's very fact-intensive. So sealing orders, so this is where the judge will have a hearing, as they should. Sometimes they don't, but they're required to have a hearing. And they want to seal certain documents that are in court, and this is for protecting those rights, like I said before. Sometimes it's for disqualifying a judge. So usually this is about if you're in court and you say this judge has a bias, they know this person, they've ruled this way, they don't like me, whatever it might be, that's public because there needs to be some sort of understanding as to why the decision was made. Like I said before, sunlight, we need to know why these decisions are made. Conflicts of interest of attorneys, those are more or less treated the same, except this exception is carved out in this Mather case, which is basically saying that it talks about rumor, gossip, scurrilous allegations. So a court can basically look at one of these things and say, if someone's trying to disqualify an attorney and they're kind of just making stuff up, they're saying, well, kind of what I said before, well, I saw this attorney having a drink with this other attorney at the bar a week ago, or maybe even something a little more intimate. I don't know. But, that can be sealed. I mean, if you're going to go into court and you're going to make up stuff to try to get an attorney disqualified, it's not fair to them if it's not true, because that gets into slander and libel. Other things where sealing orders might be pertinent, disqualification defense counsel is basically the same thing. Interview tapes, which also gets into wiretaps, those can sometimes be restricted. Competency hearings and insanity defense. So that's when somebody tries to plead insanity. You have to have a hearing for that. Those always get a lot of attention because pleading insanity is something that gets a lot of attention in public, because usually it's perceived as people trying to get out of a crime. It's not really that, but that's how it's perceived. So those always get a lot of interest. And one of those where it was very important was when the Unabomber was on trial, Ted Kaczynski, he had a competency hearing, and there was a lot of litigation about whether or not those documents would be public and whether or not the public had access to them. So in insanity defense hearings, if there's a court-appointed psychiatrist, because they're acting as an agent of the court, usually that's public. But if it's a hearing regarding their mental capacity, that can be seen as private and sometimes sealed. The food is here. I'll hurry up. Anyway, so wiretaps. So the essential nature of wiretaps is that they're private, and it's the government getting okay from a court to listen to your phone, essentially. So there's something called Title III, which is a federal law. It's something that Congress put in a spending bill that basically governs wiretaps. And the courts are a little more apprehensive to let these be public because they're usually always litigated. Usually always someone is saying, you shouldn't be wiretapping my phone. This is where Fourth Amendment rights come in, which is a story for another presentation. But just because the public's curious about it doesn't necessarily mean that there's a right to it. And also courts have been very apprehensive to allow reporting on all sorts of wiretaps because what they don't want to incentivize is people doing their own wiretaps. And they specifically said in some cases wiretapping is not a constitutionally protected method of news gathering. So search warrants. So this, if anyone here has used the Bing AI image generator, anybody know what that is? So I put search warrant in and this is what it came up with. So it's a guy, they all had dogs in them for some reason. I don't really know why. It was always a guy in a hat with a magnifying glass with a dog. But anyway, so search warrants are the same as wiretaps essentially, but instead you're going to search someone's house or their car or their office or some place that is private that the police can't access without a court order. But members of the public don't have right of access to these usually. This is somewhere where we have a circuit split, which is what we talked about before. Sometimes they'll say there's no First Amendment right of access to these because it's private, because it's, this different sort of police investigating and news gathering. And also because if you're reporting on search warrants, it's information that the government is keeping secret as part of an investigation. So sometimes courts will say that secrecy is warranted because we signed the warrant. So we need to keep this going until it's an open court, then you can report on it, is basically their logic, because you can't keep it secret forever if you're trying to use it to convict somebody of a crime. Eventually it's going to be an open court. But this is another guy with the dog. Other circuits have looked at it differently. They've said, as in the Eighth Circuit, you're filing this in court, which means it's a public document, which means that there is access to it. Sixth Circuit is not that way, by the way. Sixth Circuit is one of the places that says it's private. But this is a place where we have a circuit split, and usually what happens is that the Supreme Court comes in and takes a big case on this issue. They will not do it. They won't take any Fourth Amendment cases, so I don't anticipate this being resolved anytime soon. But this is an instance where there's kind of a discrepancy in the law. Grand juries are almost all treated the same. So grand juries is when you're indicting someone of a felony, and those are all done in secret. If an attorney says what's going on in a grand jury before the indictment's public, they can get in a lot of trouble. It's bad news. This is also, by the way, a Bing image generated. You can see on the desk it kind of has like the scales, but it didn't really do it right. But anyway. But for journalists, that risk that comes with reporting grand jury materials, it's really not as founded. You might get a little heck from a judge who doesn't know what they're doing. But if this is leaked to you, then it's already been made public. That's not your problem, somebody else screwed up. You can report on people screwing up as much as you want, which is what this multimedia case says. You know, if it's been leaked, there's nothing the government can do about it. They can't get it back. So this is what a docket looks like. It's very easy to read, as you can see. But so if you're reporting on a court case, one of the things you'll do is you go to the docket, which is what the court puts out. They'll put out every document that's been filed in a case, you know. If there's a complaint filed, which is basically saying, this person wronged me in this way, here's why I'm entitled to relief. Or if someone's been indicted, you'll see the indictments at the top, and then they'll have pre-trial hearing, the attorneys were present. That'll all be in the docket. So, you know, event type, that was a minute order, granted a motion, what day was filed, internal reference links. So that's from How to Read a Docket, if you want to look more. Federal documents are on something called PACER, which is Public Access to Court Electronic Records. It costs 10 cents a page, in case you're wondering how much your First Amendment rights cost. I think it's ridiculous, but I also don't have any money because I'm in law school. But anyway, so this is how federal courts organize their dockets. Accessing the docket itself is free. So you can go and look at the actual, you can see a complaint's been filed, but if you want to read it, you got to pay 10 cents a page, up to $30. And that adds up. But there's a lot of ways. They've been sued about it all the time. It always is upheld because the courts aren't going to turn down free money. So, but I don't want to get too cynical. So, but there's other ways to access these federal documents. So this is something called Court Listener. It's another way to access. So if there's a federal document that's been accessed on PACER, sometimes people upload it to Court Listener so that way other people can get it for free. It's a very nice collaborative exercise. And also, Andy Geronimo's not here. But this is what he said to me 2 days ago when we were looking through Court Listener. These things are impossible to search for no reason. So if you're wondering why I'm not going to take you through that, it's because if I tried to find something, it would take like 10 minutes. So you guys can figure that out on your own. And if you're not getting it, then you're doing it right. But yeah, so Court Listener, there's all sorts of other things if you just look around to get federal documents. But now we'll go into Ohio courts with the time I have left. So there's a basic outline of the structure of Ohio courts again. So the Ohio courts have something called the Rules of Superintendents, which is, they're not law, but they kind of act like law. So it's something the Supreme Court passed that tells their own courts how to operate. It says, it's basically, like I said before, a restatement of these principles. So one of the things that's in there is court records are presumed open to public access. So that's the Supreme Court telling its courts in Ohio, you guys have to give them these documents. And like I said, they're not law, but they get cited a lot in court opinions. So they kind of have the effect of a law, but they're not a law. And like I said, but they are cited a lot in law. So they're just guidelines for judges. They're administrative, basically just telling the courts what they're supposed to do. Because every Supreme Court in every state governs the practice of law in its state. So when we apply for the bar, when we apply for our law license, we have to go through the Ohio Supreme Court to do it. So in this State ex rel Cincinnati Enquirer versus Lyons case, it said court records are presumed open public access. It's just a restatement of that principle. Like I said, the courts follow them a lot to the point of quoting them. Also, if you're looking for a job in the future at a place that has a lot of litigation, the Cincinnati Enquirer is in a lot of these cases. They are trying to get a lot of documents that the court doesn't want them to get, which I think is kind of cool. So if you're looking for a place to work, I'd look up Cincinnati Enquirer. But broad judicial construction in favor of access to records, can only restrict by clear and convincing evidence. Basically, the principles are almost exactly the same, federal, state. You have a right to these documents. The court has to show that you can't have them. This is one of the superintendent's rules. It tells a court how it can restrict a document. Public policy is served by restricting public access. Law exempts the document, so that where that comes in handy is Ohio has a public records law, but it has something like 300 exemptions. And going through all of those when you're trying to get a document through the public records law can be tedious and frustrating. So I recommend if you're trying to get a document, don't use the Public Records Act. Try to go through the superintendents or just try to say, you can't not give this to me. Because then you'll have to go through all the exemptions and that's a mess. But, you know, I've been saying the same thing for like 20 minutes. It's weigh it against public access. Is it prejudicial? Is it not? Same thing here. Here also it talks about redactions. So sometimes what courts will do, if there's some information in a document that they're saying, oh, we think this might be prejudicial, but the rest of it's fine, sometimes they'll redact or other sorts of things. And also in state courts, like I said before, this is where a lot of felonies come in. State courts also deal with domestic violence and juveniles, and that's somewhere where the court you'll see initials usually in these cases because there is this overriding interest in protecting these people's identities. For domestic violence, it's pretty straightforward, but also for juveniles, there's this assumption that they're kids, they're learning, we're not going to put them on blast until they're 18. Court hearing access, kind of the same sort of deal. Fundamental right in the Constitution to attend these, and the qualified right attaches if there's historically been open to the public. So that's kind of where common law comes in because it's looking back into the past saying, has the public traditionally been allowed to attend these things? And also public access playing a fundamental part in the hearing. So that's kind of the sunlight doctrine like I talked about before. Whether or not letting the public know what's going on is important, where in court, I think it always is. So this talks about giving deference to the public right of access when a petitioner is given opportunity to be heard. So one of the cool things you can do if you're in court, if a judge is going to seal a document, which I get into later, they have to have a hearing. And you can just get up and say, I don't want you to seal that document. And they might look at you funny and wonder why you're interrupting them, but you're allowed to do it. Then you have to get a lawyer. Don't do it and then just stand there and be like, I win. Definitely get a lawyer because the judge is probably going to be really mad that you interrupted them, but you're allowed to do it. So you have to, there's to be notice. If you're going to restrict a right, notice, which is the hearing, and an opportunity to be heard. So you have a right as a journalist and as a citizen to access these documents, and they have to give you a reason if they're going to do it. Here's some other principles. So if you want to go through the Public Records Act for something else, maybe not related to court documents, you have to get a mandamus request, which looks like that. Ask your lawyer. Don't try to do it on your own. But Public Records Act is supposed to expose the government activity to public scrutiny, except the government keeps putting restrictions on it. It's supposed to get broad access. They exempt a lot of things. People have a right to know what the government's doing. I was going to search the court docket, but I'm running low on time. But in Athens County, most Ohio counties have this. The big ones especially do. The smaller ones should be getting it. eservices.athenscommonpleas.com. So you can go through the whole Athens County Court of Common Pleas. If you know the name of somebody, if you know the case number, even if you know the date, it'll give you the whole docket for free in Ohio. You don't have to pay. So that's nice. But it will tell you how much the attorneys paid to file the documents, which can be kind of fun and scandalous. And this is what I talked about, objecting. These should be open to the public. Sometimes judges will seal things without telling anybody because they think they can. And then that's when you have to call a lawyer and get even more deep into the legal weeds. But you can voice an objection, say, stop having the sealing hearing until I can talk to a lawyer, and then they'll get mad, but then they'll do it. So just keep it in your mind that you're right. And it comes from these basic ideas. You should be able to access these things. And one of the things talking about dockets, the Senate just passed a bill in the House in Ohio a few months ago, HB 567. In the next 12 months, every county should have an online docket. Whether or not they get it done is another question, but in the next 12 months they should. But Athens County has one, all the big counties have one. But that's all I have if there's any questions anybody has about court hearings or court access or access to court hearings. Nobody. Okay, well, thank you very much.
Thank you, Patrick. As you can see, lunch is being set up, so we are going to go ahead and break now for lunch. Obviously, we are all sitting here at this table. If anyone has any questions or has any thing that you would like to talk about with any of us, please feel free to come up to us and talk during the lunch hour. But other than that, feel free to take a break, grab some lunch, and then we will get started again maybe a little before 1, depending on how everyone's eating schedule is going. So thank you all, and we'll be breaking now. We're going to get started again so that we don't keep you too long on this Friday afternoon. The next presenter we have up is our certified legal intern, Jake Cohen. Jake will be speaking about the First Amendment right related to news gathering.
Okay, so I'm going to be talking about your right to gather news outside of the courtroom. So now, what is news gathering in the eyes of the law? Well, it's practically what you think of when you hear the word news gathering. It's journalists, reporters, investigators, etc., out and about collecting news through interviews, press conferences, phone calls, video and tape recordings. It's the gathering and disseminating of your information. It's communication between your sources, both public and confidential. And all of those things, that's what you think of when you hear news gathering. That's what courts and laws typically think of as well. And now, why does knowing those rights matter? Well, some student journalists at Ohio State were pepper sprayed by the police when reporting on protests back in 2020. I believe there was a curfew implemented by the mayor of Columbus, and some student journalists were going out and reporting on the curfew and the protests and whatnot, and they were pepper sprayed by the police. And back in 2017, in this very building, 70 people were arrested during a sit-in protest. And recently, after the East Palestine train blew up, Mike DeWine held a press conference about that explosion, and a journalist was actually arrested just for being there and reporting on the press conference itself. And this is not just an Ohio thing. This happens all across the country. 2 reporters were arrested in Alabama for publishing information about how local county officials mishandled COVID relief funds. So stuff like this can happen, and it's important to know your rights and be prepared if it does happen. And now, I want to make it clear that, there's things the law says, and there's also, the ethics to think about when we're talking about this stuff. So what the law says you can do is not always the most ethical or moral thing to do, so keep that in mind. You have a reputation to think about, and colleagues, sources, and law enforcement that you want to maintain trust with. So just because it's legal doesn't necessarily mean you should go run wild and do whatever you can, because legally you could. But then again, I'm not a journalist, so it's up to you. Just make an informed decision about your career and your community. So now a bird's eye view of news gathering. From 1972, so this has been a quote that has been cited a lot. It says, "News gathering is not without First Amendment protections." And if you're thinking, what does that mean? You're just like everybody else, because the Supreme Court has never elaborated on what the heck that means. But it's at least quoted in a Supreme Court case saying that somehow, some way, news gathering has First Amendment protections. What those are up for debate. But another quote from that case is that you undoubtedly have a right to gather news from any source by means within the law. So, going back to that previous slide about ethics, if it's within the law legally, you're allowed to do it. You're generally able to go gather news at places that are open to the public. You're not necessarily able to just waltz on into places not open to the public because you're a reporter or a journalist. There are special carve-outs and exceptions that apply to journalists in Ohio, and I'll be talking about some of those. You do have a right to record law enforcement, and I also want to bring up the difference between constitutional rights and legislative rights. Part of my presentation is about constitutional rights that are granted to you by the First Amendment, and other things such as special carve-out exceptions for journalists are legislative rights given and made by the state legislature. So I know a couple other presentations have touched on what we call the forum, but in the context of news gathering, it does matter. So where you go to gather news affects your rights and how much rights the First Amendment gives you, and legally it's known as the forum. So there are three major forums. The first one are public forums. So when you think of, like a protest or a demonstration, typically happens streets, sidewalks, parks. Those are known as public forums, and you'll be granted the most, protection of your free speech by the First Amendment there. A limited public forum, think of city council meetings or press conferences. You're still afforded rights under the First Amendment, but there can be practical limitations, for like a press conference. If it's held in this room, we can only hold so many people in this room and only give so many people a chance to speak because of practical time limitations. So that's something that you can just have in your mind to think of as what a limited public forum could limit you to. And then non-public forums such as military bases or airports, typically you're not going to have a ton of First Amendment rights here to go gather and collect news. I think we can all understand the reasonable element behind not wanting journalists invading military bases asking for questions. So based on those forums, the First Amendment has differing levels of protection for your speech, as I've mentioned. And now I'm going to talk about your right of access to certain government information and locations. So this case, Houchins v. KQED, Inc., is the landmark case in right of access to government information. So this case had news personnel that wanted to access prison and access the facilities to, report and record and let the public know what was happening inside the prison. The news personnel argued that they had a First Amendment right and a 14th to access the prison, but the Supreme Court disagreed. The court ruled that neither the First or the 14th Amendment grants the media, quote, a special right of access to governmental buildings or information different from or greater than that accorded the public generally, unquote. So news reporters were not permitted to access these prison facilities despite the potential newsworthy story that could have been gathered there. So this shows us that the ability to collect information is not absolute, and although the First Amendment protects information gathering, it does not provide blanket access to information within the government's control. And you might be thinking, well, going into the prison, shedding light on what's going on, the public has a right to go in there and broadcast what's happening. But the Supreme Court doesn't care, and they disagree. And they say that we must not confuse what is good, desirable, or expedient with what is constitutionally commanded by the First Amendment. So even with this quote, you can see that the Supreme Court almost recognizes what good, access to this information could do to the public, but constitutionally, it's not a given right, so that's why they're ruling in that direction. And so what does this all mean for you practically? So there is no constitutional right to have access to certain government information or to require a certain level of openness from the government. And now this is speaking purely from a constitutional standpoint. Certain exceptions may apply, such as a statute allowing, right of access or whatnot for certain documents. But constitutionally, there's not that right. And just because you have the right to gather news doesn't mean the government has to give you access to certain information, whether it be physical documents or locations. Again, that's just constitutionally. Certain exceptions may apply, such as the Ohio Public Record of Document Inspection. And now to kind of encapsulate what this means practically, imagine, as journalists, you want to go to the White House and report on what's going on in the Biden administration and whatnot. We can all understand the First Amendment interests in going and reporting on that. But if we have every John Hancock walking down the street that wants to report on the White House, practically just because First Amendment, you want to report on it, that doesn't mean you have the right to just go in to any government building that you want to report on it simply because you're a journalist. So how does the law determine if the government can restrict my right of access at certain locations? So how does the court determine that this prison not allowing journalists to access it for First Amendment reasons, how do they determine that? And it's essentially a three-step analysis. So the first question you're going to ask is, has the government selectively delimited the audience to the access of information? So say in that prison case, for example, if they said, hey, only journalists are banned from here, but, if you're a coal miner, you can come in here and, take notes or whatever. That would be selectively delimiting the audience, specifically almost targeting not allowing journalists or reporters to come in for, I would imagine, reasons that they would have. And now, going off of that, what is the government interest in denying access? So why does the government not want journalists or reporters or whoever coming into the prison? And then third is the government's interest reasonably related to the means of accomplishing that interest? So if they don't want in the prison, if they don't want every reporter coming in, they're not going to allow reporters to, if they don't want reporters coming in to report on stuff and disrupting prison, schedules and whatnot, then they're going to ban everyone. Is that reasonably related to the means of accomplishing their interest of not disrupting prison, schedules? So if the government rule does not selectively delimit the audience and it's reasonably related to the government's interest, then the denial of access to information will generally be upheld. So just keep these three questions in mind. How a court's going to rule what's a legitimate interest in denying access or how it's reasonably related. That's what lawyers are for. I can't give you a straight up answer here today, but those are the three factors to consider, if you're denied access somewhere. So now we've talked about where you're able to gather news and information. Let's talk a little bit about when you're actually there and how you gather and publish your news. So, as a journalist and a reporter, can I show up to emergency scenes to gather ongoing news? Now, this ORC 2917.13, that's the statute, which is just a fancy word of saying the law. So if you want to go read this in depth, that's the statute number. So this statute essentially says that no person shall show up to an ongoing emergency and hamper law enforcement and, the ongoing duties of whoever's handling the emergency. But I bolded this B here because it says nothing in the section shall be constructed to limit access or deny information to any news media representative in the lawful exercise of the news media's representative duties. So this essentially is saying, hey, nobody can go and, disrupt what's going on at an emergency, but it's basically laying out that the purpose of the statute is not to limit journalists or reporters' ability to show up and report on an ongoing emergency that is newsworthy. So in short, can I show up to emergency scenes to gather info? I would recommend you to be careful. This doesn't grant you any extra rights just because you're a media representative. And as I said, it clarifies the purpose is not to prevent your presence as a journalist or reporter, but you're not granted any extra rights as a reporter. So, give whoever's there, whether it's firefighters, police, a medical ambulance, give them space and let them do their thing. And just be reasonable, If you can tell something's a dangerous ongoing emergency, but you still want to report on it, be reasonable, But of note, if a cop or, a firefighter, whoever tells you to stop recording or taking notes, they cannot do that. You have a right to record whatever's happening in front of you and take notes. So, you have a juicy story that you've heard of and you want to call someone to get more information about it. Will you get in trouble? Here's the statute for that. Telecommunications harassment. So, in Ohio, journalists are given an exemption from a telecommunications harassment law So if I were to call someone and ask them for information a couple times saying, hey, how'd you find this out about me? If I'm calling them a bunch about that and they accuse me of harassing them over the phone, I could be in trouble. But as a journalist, you could potentially call someone in order to get information or ask questions about pertinent information important to the public and have a defense to liability under the statute. Because this specific carve-out, this is the actual statutory language. So it basically says that telecommunications harassment does not apply to a person who is employed through all those things. But I would urge you to do the practical thing here. Just because you may be legally exempt from telecommunications harassment, don't call your neighbor every night at 3 a.m. This is not an invitation to relentlessly, call people day and night. The spirit of the statute is so that you don't get silenced for trying to publish a story. So, for example, say you contact the local mayor, who's the mayor of Athens. So say you call Steve Patterson, and Steve Patterson tells you, or you call Steve Patterson to ask him about a story, about a local ordinance or whatnot. You call him and he says, don't ever call me again or I'll say you're harassing me. You have a good defense to any liability or any threat under this statute, reaching out to ask for a comment from the mayor every time there's a potential story. That's what this statute is designed to protect. A politician, a local official, whoever can't threaten to silence you under this statute. You have a right to call them every time, they might have relevant information for something that's newsworthy to the public. Do I have to reveal my confidential sources? So, confidential sources, it's a pillar of, journalism and reporting. So, if it ever comes a time where you feel like you might have to reveal confidential sources or someone's threatening you to reveal your sources, do you have to? So, no person engaged in the work of or connected with or employed by any newspaper or any press association for the purpose of gathering, procuring, compiling, editing, disseminating, or publishing news shall be required to disclose the source of any information procured or obtained by such person in the course of his employment. So, if you fall under that, then you cannot be compelled to reveal any confidential source of where you got your information. The same highlighted portion applies for those if you're employed by a radio or a broadcasting network. Reasoning behind this is to protect the relationship and trust between journalists and their sources. I just want to caution you that there are some very extreme exceptions to this, such as a criminal defendant's Sixth Amendment rights, but that is very rare and, a very, very small percentage of cases or examples that might come up from this statute. So, this is not just limited to Mayor Patterson saying, hey, pal, you have to tell me who your source was and how you got that information. This right extends all the way to judicial proceedings, whether being subpoenaed for a grand jury or, being a witness at a trial or whatnot. And the purpose of shielding revealing sources is to protect the press from, ruining trust between confidential sources. If confidential sources weren't protected, there'd probably be a lot less information that the public needs to know being disseminated around. I do want to highlight that this statute doesn't prevent you from disclosing a confidential source. Instead, it permits you not to disclose it. If you ever feel like you need to reveal a source for whatever reason, potentially a defense to a defamation claim, you are able to do that. Just know that you don't have to reveal the source. And if it ever comes to it in a judicial proceeding, generally as a journalist seeking to gain the privilege of non-disclosure, you will have to show how you fall within this statute. So just be prepared to provide some sort of evidence that you gathered this information in the course of being employed. What that evidence would look like and be sufficient to. That's why there's lawyers. I can't give you a concise answer of what that might look like here today. But just know that if it ever came to it, be prepared to show how you qualify for this statute. So can you record your interviews and conversations? And I know we didn't have the actual video, but we heard the audio of that one conversation from NACA's presentation earlier. And when he asked, "Can I record this?" and the lady on the phone said, "No, absolutely not. You can't record it." Well, if he was in Ohio, legally he could still record that conversation, even though she has said, "No, you can't record me." That's because Ohio is a one-party consent state, meaning only one of the parties that is being recorded has to consent to being recorded. So if I'm walking down the street and I see Mayor Patterson and I want to ask him a question about whatever, and I'm running up to him, I got my phone that I'm recording with, and I say, "Mayor Patterson, can I record you? You know, I want to ask you about whatever." And he says no. You're still a party to that conversation, and I'm imagining you've given consent to yourself being recorded. So even if he says, "I don't give you permission," you can still record this interview. Now, if someone came in here this morning and hid a microphone above us here and nobody knew it, and none of us in this room consented to this microphone being here recording us, then that person would be in trouble if they weren't in the room because they weren't a party to the conversation and nobody in this room knew or consented to being recorded. So essentially think of it as, it's not an invitation to go eavesdrop on, someone's office that, you're leaving a microphone behind. That's not what you're legally allowed to do under this statute, but you are legally allowed to record phone conversations and, face-to-face conversations that you are a part of, even if the other person says, "I don't want to be recorded." And now, this is limited, as I just mentioned, to typical eavesdropping. Of course, you can record someone on the radio, even though they might not know that you're recording them. They're broadcasting it publicly. For anybody to bring a claim that they were illegally recorded under the statute, they have to prove that they had a reasonable expectation of privacy for their conversation. Hence why a radio broadcaster can't claim, "Hey, this was a private conversation." Well, he's blasting it on FM radio, so it's not a private conversation. And the party that tries to argue that they were illegally recorded has the burden to prove that their interview was in fact recorded illegally. So this is a further statutory language of, the statute. So where it says oral or electronic communication, courts in Ohio have ruled that in order for something to qualify as an oral or electronic communication, that person has to believe that their conversation was, private or that they weren't being recorded. So that's why a radio broadcaster is not going to have any claim under this statute, because under the statute, it technically wasn't an oral electronic communication, that had a reasonable expectation of privacy. And also, this highlighted portion in section 4, this end line that says, "for purpose of committing other injurious acts." This is basically kind of a catch-all that the legislative made that basically said you can't really use this for nefarious purposes, essentially. With this catch-all, it's got to be like legitimate reporting. It's them reinforcing that you can't just go eavesdrop on every single, building or what have you, So for the purpose of this statute, make sure it's like a legitimate conversation that you're recording with within your job scope. So now you've gathered all your news, and now you want to publish your news. Let's talk about that. The leading case on that is a Supreme Court case called Bartnicki v. Vopper. It's a Supreme Court case from the 1990s, and it came from Pennsylvania about a teacher union dispute. And this is important. At that time in that town, it was a major local public issue. So, private conversation between officials on the school board was recorded unbeknownst to those being recorded. Nobody knew who the mystery recorder was, and these individuals did not consent to being recorded. So, one day, a local radio anchor received a recording in the mail of the conversation between the school board officials from the mystery recorder. The radio anchor broadcasted the recording of the conversation on local radio station, essentially exposing the school board officials for, some scandal or whatnot. And then people on the school board weren't too happy, so they sued the radio anchor for broadcasting their recorded conversation that, was recorded illegally. So, the legal question is, does the First Amendment protect the lawful dissemination and publication of information despite that information being illegally obtained? There was no dispute in this case that the mystery recorder recorded this conversation illegally, but what about the radio broadcaster? All he did was wake up and his mailbox was full with the tape recorder of this, crucial piece of news that he wanted to publish. He didn't obtain it illegally, but is he going to get in trouble for publishing a piece of information that was illegally obtained? So there are 3 key factors that you want to keep in mind if this situation ever happens to you. Did you legally obtain the information? Well, in this case, the guy just woke up and found it in his mailbox one day. He didn't do anything illegal. Did you participate in the illegal gathering of the information? This guy is not the guy who recorded it. He didn't tell anyone to illegally record the conversation. He just woke up and found it. And is the information a matter of public concern? If this recording was about what the people down the block had for dinner and they broadcasted that or what have you, then that's not a public concern. But for this town, at this time, the school board issue was a major matter of public concern. So, if you legally obtained the information, you didn't participate in illegally gathering the information, and it's a matter of public concern, the First Amendment can protect you from liability for publishing illegally gathered information. Lawyers don't like to say things in absolute, so that's why I've bolded and emphasized can, because I don't want to make any promises that I might not be able to keep, but the First Amendment can protect you from liability if you succeed in proving these 3 factors. So, just an interesting quote from that case. The right of privacy does not prohibit any publication of matter which is of public or general interest. So essentially saying just because something's private doesn't automatically prohibit, the general public from hearing it. Now, this does have limits such as national security or certain expressive messages. And so just view this as not an invitation to publish every piece of information that might have came to you through a sketchy means. Really make sure it's something that is pertinent to public information. And you want to feel confident that what you gathered wasn't illegally obtained or gathered. So be prepared to show how you didn't participate in illegally gathering this information, such as, the guy just woke up and found it in his mailbox one day. You should feel comfortable in saying how it legally came to you. And you should feel confident enough, if I don't know if this would ever happen to you guys, but just imagine you're going in front of a grand jury. Would you feel comfortable enough, being under oath and testifying that, I got this stuff legally? If you're not that confident, then, just think long and hard before, publishing a piece of information that someone might get really upset about. So news embargoes, will you get in trouble for news embargoes? So a news embargo, someone gives you a piece of spicy information but says hold off until Friday, and it's Monday, so you got to wait the rest of the week to publish it. So in this scenario, imagine a district attorney comes up to you and says, hey, on Thursday we're going to arrest so-and-so and charge him with robbery. You can write up a story about it, but please wait until Thursday to publish the story. So what happens if you decide to jump the gun and publish the news story on Wednesday? Will you get in trouble / arrested? Probably not. No, you will probably not get arrested. But think long and hard about the ethical dilemma and what it could do to your reputation and career. That district attorney will probably never talk to you again about a juicy piece of gossip that you might want to report on because you betrayed his trust. But you'll probably not get in trouble or arrested. And now, kind of moving to the future of news gathering. I know the other presentations have talked about the internet quite a bit, so I'm jumping on the train. So web scraping. Web scraping is a way to automatically access and record information already available online. It is faster than manual searching and it prevents the potential for human errors. So I know Patrick was up here talking to you about court dockets. So in Cuyahoga County, where we're at, the Cuyahoga County court docket has a page where you have to accept the terms and conditions. And under their terms and conditions, you have to agree that you're not going to have some sort of software that sifts through all their information looking for, I don't know, whatever you'd be looking for in their docket. So in this jurisdiction with that court docket, you can't do that. So you got to go look for everything manually, and that takes a lot more time. So I could hire an army of yellow minions to scrape the web manually for this data that I'm looking for, and legally I'd be fine. But in some jurisdictions, I could be in trouble just because I have a computer do it instead of actual people. So is this an infringement on your right to gather news? We don't know. It's a new battleground in First Amendment law. There's a few cases now that are starting to roll out, but nothing definitive has been decided. So, if you're tech savvy and you like going on the internet to get your sources, keep an eye out for this because it might be relevant to you in the near future. Does anyone have any questions?
As far as the definition of whether you're engaged in journalism, I saw that some of those are quite specific about you being employed.
Mm-hmm.
Whereas I know 1997 Titan Sports versus Turner Broadcasting was much more broad as defining journalism for Shield as an individual who's engaged in disseminating news, not mentioning employment. For people in this room who may not be employed by news organizations, what implications does that have?
We've actually went and talked about this back and forth quite a bit, and we couldn't really come up with a definitive answer if, student journalists would qualify for that, but there is good arguments to be had on both sides. As of right now, there's no real case law challenging, if a student journalist qualifies for these. If there were, we'd be able to report that on you, but sometimes in the law, you don't really know the whole answer until, the scenario pops up. So I wish I could give you a better answer, but I would say that be prepared to argue extensively why, as a student journalist, you would fall under some of these statutes to get protection.
Similar to that, a lot of newspapers now use freelancers and contractors for coverage, and if they are not actually employed by the newspaper but are doing work under contract, would they be covered?
That's a good question. I think part of it, from my general understanding of this law and how it, interprets who's a journalist and whatnot, I think their career would be relevant in that if they had been a long-standing, renowned reporter that was known for their years of work at whatever newspaper. If they're no longer contracted, or however you phrased it, if they're in that position, if they have a reputation and are well known, in the journalism community and that community as a whole, that could definitely help them in that aspect of proving that, I might not be in the same role, but this is, I'm doing this as my career for a, legitimate newspaper as a, being contracted or whatnot. Now, I'm not pretending to be an expert on this, and I'm not saying take that for law, but that is my initial gut reaction. I think it would be harder to prove if you're fresh out of journalism school, but if you're a renowned reporter that you can point to your career as relevant factors, I think it'd be much easier to qualify under that statute. Yes, and the real experts are here to give a more concise and accurate answer.
And I wish he was referring to me, but I actually have a text from our director, our fearless director, Andy, who is watching remotely. So his response to these questions is that there are new voices laws that have not been passed in Ohio that would protect student journalists in some of those situations. And if you are interested in that or want to follow up about it, definitely talk to legislators about it, because as you recognized with your question, Andrew, you know, a lot of times the Ohio legislature hasn't necessarily caught up to where we want them to be. We think that the definition is very narrow and it doesn't take into account a lot of these questions that we're talking about today, where, you know, what if you're a freelancer, or what if you're a student journalist? What if you were fired but you have a ton of bylines and it's what you've done your whole life? So we agree. We wish the law was more clear. But that's just kind of the state of the law right now. Also from Andy, apparently Congress has talked about a national shield law. So that's something else to keep in mind. But then just finally, just a quick plug, definitely feel free to call the clinic. As Jake did a really great job answering, we don't always know how courts will rule until the situations come up, which obviously you don't want to be the person who's bringing it in that situation, but we can do our best to help you navigate some of these thorny areas. Any other questions? No? All right. Well, thank you so much, Jake, for that. And then for our final presentation of the day, we have Brooke talking about defamation. So welcome, Brooke.
Hey everyone, I'll try to be quick so we can get out of here on this Friday. One sec. Okay, how many of you have heard of defamation or have a general okay, good, we've got some hands raised. So, if you have a general idea, assuming I'm done with my presentation today, the Indy decides to write about me. It says, Brooke White is a really bad public speaker. Who thinks I could go after them for defamation? What if, instead of calling me a bad public speaker, they said Brooke White lied today during her presentation? Show of hands. It depends. For the first thing, it's an opinion, likely won't have a good claim. But if I really didn't lie about anything today, I might have a good claim against the Independent. But don't worry, guys, I'm not going after anyone. So to start, defamation. Oh, it is showing up. Defamation is all over the news. We've heard about the Johnny Depp, Amber Heard drama. We know that Amber Heard lost in the US. But what's important is in the UK, Amber Heard also said some things about Johnny Depp, but she lost her case in the UK because the judge found that her statements were substantially true. I think those had to deal with her calling him a wife beater, and judge said, this isn't defamation. Same thing with Fox v. Dominion. This was the largest defamation settlement in U.S. history, where Fox was broadcasting that Dominion's machines were responsible for changing votes from Donald Trump to Joe Biden. Dominion brought a defamation claim against Fox, saying that, you know, this is a false statement from Fox, and they ultimately settled for almost $800 million. Here's a big Ohio one. I don't know if anyone was familiar with this. This is a little over 10 years ago, but Robert Murray, big co-mogul in the state, fired 160 people. Afterwards, there was a protest, and some newspapers went to the protest, including the Chagrin Valley Times, just interviewed people about what they were upset about. These are some of the protesters who were there, just believing that Murray fired people for having different political views than he did. A lot of the signs were pretty respectful, calling him Mr. Murray and asking questions why. But Murray ultimately sued the protesters and newspapers for defamation. Murray lost on everything. He dropped some of the cases. One of the Ohio courts representing the Chagrin Valley Times thought the suit was totally frivolous, condemned Murray for bringing it, and urged Ohio to develop new laws for protections against journalists for defamation. We still don't have them, which I'll talk about in a little bit. This is the statement from one of the protesters who was sued after protesting and was interviewed by a newspaper. This was in front of the Ohio Senate in 2020, where Lisa Koicha said that the lawsuit attempted to destroy her and the newspapers financially, while she said that she would continue advocating for change about different issues in Ohio. She said, "This man did succeed in one way. While we will continue our activism, we will never speak out against him or his activities again." Defamation is huge because it chills people's speech. If you're hit with a defamation suit or even threatened, you may not want to report about it, or might even continue not reporting at all. So it's a big deal, and it doesn't apply just to journalists. It applies to us when we post on Facebook. If you hurt someone's feelings and they have a lot of money, they could try to just intimidate you with a defamation suit. What is defamation? We have two main ways of talking to people. We write things down or we speak them. The legal definition is a plaintiff, so the one bringing a lawsuit, can bring a defamation suit against a person who has made a false publication that injures a person's reputation, exposes him to hatred, contempt, ridicule, shame, or disgrace, or affects him adversely in his trade or business. These are the things that you need to succeed in a defamation claim. So if someone says to you, "Hey, I'm going to sue you for defamation," they better meet all 7 of these things. And it's not really straightforward. It's kind of hard to meet all 7 of these things. First thing is that the statement has to be false. So again, if the Athens Independent says I lied during my presentation today, but I think that they're false and I have proof showing that what I stated today was all true, that's just one thing that I would need to prove in a defamation case. Ohio recognizes substantial truth, so if the gist or general idea you're trying to get across in your statement is true, courts have typically and routinely applied that. There was a case in Ohio where a woman said that men in her community were preying on elderly women to take advantage of them. And while there wasn't any actual proof of real preying as defined in the dictionary, the court said that there could have been instances or interpretations of the word preying that would have made their statements substantially true. So if the gist or general idea that you're trying to get across is there, then you should be good. I think it's important to know that even if you are a little misleading and trying to be a little bit edgy in your reporting, as long as there's some truth to it, you should be okay. There must be a statement of fact. So it's a little harder than I thought before I got into defamation research about figuring out what a fact or an opinion is. So I want to go through 2 scenarios from Ohio Supreme Court cases with you to see what you think. This was a case from 1990 where the plain dealer and one of the journalists, one of the columnists, talked about someone running for the Ohio Senate. The article was entitled, "Gay Basher Takes Refuge in the Closet." There were 2 other statements that were the basis of the lawsuit. Lauren Loving-Vale, who was the candidate, doesn't like gay people, has added gay bashing to the repertoire of right-wing neo-numbskull tactics, and that Vale had given an anti-homosexual diatribe. Now, if you read these in a newspaper, who thinks that this would be factual? Who thinks it would be an opinion? It's an opinion. The only issue or statement of issue was the statement of the candidate giving an anti-homosexual diatribe. That's the one thing that the court kind of spent time on, because if you're talking about people and you're making anti-homosexual statements, perhaps that could be factual, but court said these were opinions. Next thing, there was some drama between 2 different high schools in Ohio. There was a wrestling match, a fight broke out. The Ohio Athletic Association held a hearing and didn't let the Maple Heights High School compete in wrestling. Then some parents sued, took it to court. The court reversed the probation against Maple Heights, allowing them to compete. People were mad about this. They thought there was some corruption going on. So a columnist, saying Maple, meaning the high school, beat the law with the big lie. Then the columnist says Maple told a lie. And one of the other statements was, anyone who attended the meet, whether he be from Maple Heights or an impartial observer, knows in his heart that the coaches lied at the hearing after having given their oath to tell the truth. Does anyone think that these are opinions? Raise your hand. Does anyone think these are facts? Opinions. So the reason why is talking about the second case first. Ohio courts look at 4 things to figure out if something is fact or opinion. The language at issue, whether you can actually verify this statement, the context, meaning what are the words surrounding it, and the broader context in which it appears. Are you in the news portion of a newspaper? Are you in a column? For this case, the first 2 things led the court to believe that this could have been factual. Calling someone a liar is actionable. And it's also verifiable because this columnist was reporting about an actual event. So you could go and either ask the columnist or the people who went to the event to back up the facts. But ultimately, the reason why the court said it was an opinion is because of the words surrounding the statement, and the actual broader context, which is where it appeared, supported it was an opinion. So big thing to take away is that courts, when they're looking at these 4 factors, not a single factor is not dispositive. They'll weigh them, they'll figure it out. If, like, you're in a column, this is typically a place for hyperbole or cajoling. People don't really think it's impartial news reporting. And if you have the words, in my opinion, or I think, it's more likely to be an opinion. But again, if you say I think and then have a really factual statement come after it, just saying in my opinion isn't going to save you. For the plain dealer case that we just talked about, which is having to deal with those statements about the homophobic Ohio Senate candidate, here they looked at the specific language, says it's ambiguous. What do you mean about an anti-homosexual diatribe? What does it mean to be a gay basher? General context, again, it appeared in a forum page with commentary. Courts are likely to find, but it's not guaranteed, that forums and commentary support that this is the columnist's opinion. You can't really verify these statements. Again, the court kind of considered maybe you could verify the anti-homosexual diatribe, but calling someone a gay basher, how do you verify that with actual facts? And again, columns are sarcastic, have a dramatic, hyperbolic stories, and the author also had an opinion of being an opinionated columnist. So if you become an opinionated columnist out there, maybe you'll be a little more protected. Continuing along the line, self-centered greed, ruthless spectator, exorbitant rent, you are a con artist. Ohio courts have held to be opinions, but when a statement has a precise meaning that is likely to give rise to factual implications, they're more likely to construe them as factual. In the case of that praying case I just talked about, a court could say that this could be a verifiable statement, didn't make that definitive ruling, and also calling someone a racist is found to be factual in many Ohio courts because it's unambiguous and pejorative. This kind of seems a little bit redundant, but to be sued for defamation, the statement itself has to be defamatory, so it's not enough that it hurts your feelings, it just has to be, how does it affect you? If it's a statement that hurts your reputation or hurts you in your career or your trade, that's going to be likely a defamatory statement itself. If you're accusing someone of committing a crime, engaging in perjury, or doing something of moral turpitude, the court's just going to say, yep, this is a defamatory statement, but you're still going to have to prove all of these other things that I've talked about and we'll talk about. Statement must be published. This is a big deal, I think, because I didn't realize that if I just communicate to one other person something that's defamatory, even verbally saying something to one other person is publication. Doesn't have to be written, doesn't have to be widespread or widely disseminated, doesn't have to be in the newspaper. If one journalist is talking to another and you're able to prove that this has actually hurt you, even though it's just 2 journalists talking, that could be enough. A little harder to prove. The statement must be about the plaintiff. This is a constitutional requirement. So although defamation is a state law claim, meaning it comes up under Ohio law, we have principles from the Supreme Court of the United States guiding how we look at defamation. So if a newspaper publishes a defamatory statement about someone else, I can't sue that newspaper for defamation because it's not about me. Generally, you have to show that you've been harmed. So like I said, it's not enough to say that the statement hurt your feelings. You have to show that it's hurt you adversely with your reputation or in your trade or business. But with crimes or moral turpitude, like I just mentioned, courts are likely to just infer harm because those statements themselves have such a big impact. But if you're not dealing with accusing someone of a crime or a moral turpitude type thing, you're generally going to have to show that the statement has hurt you. This is like the last big part. It's kind of complicated, but you have to know who you're reporting about, and depending on the person's status also affects what they have to prove. So if you're a journalist who's just talking about a regular person, in order for that person to succeed on their defamation claim, they have to show that you were negligent, and I'll get into this. But if you're talking about a public figure or a limited public figure, so like let's say I'm talking about someone in the community who owns a business, and that person in the community then engages in discourse, they might qualify as a limited public figure because they've injected themselves in the public eye for this issue. If you're talking about people like this as a journalist, if you're getting sued, you're going to have to, it has to be shown that you acted with actual malice. So where this actual malice came from is a Supreme Court case, New York Times versus Sullivan. One of the commissioners of Montgomery, Alabama, sued the New York Times and a journalist for things that appeared in a newspaper. These were the statements that appeared in the newspaper. There was a student protest. People were locked inside of a dining hall. The police showed up with shotguns. And there was something else with just violent calls and responses to Dr. Martin Luther King's speeches. So this commissioner brought suit against the New York Times, even though the New York Times never referred to him or the commissioners in the city of Montgomery. But he felt like he could bring suit because the statements referred to the police, and he thought that because he worked for the government, people could think police refers to the commissioner. It was a weak argument. The Supreme Court disagreed. But the most important thing to take away from this is that as a commissioner, he was a public official. He could not prove that the newspaper acted with actual malice, which means the newspaper didn't know that the statements were false or recklessly disregard the falsity of the statements. And this is true even though the New York Times had actual articles and facts in its possession that could have disproven parts of the statements. So if you're a journal or a newspaper and you have documents way back that could change the accuracy of your reporting, it doesn't make you liable when you're talking about a public official because you're not knowingly publishing false information. You may have been negligent, but that's not enough when you're talking about a government official. The reason why we have this is the Supreme Court said we have a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, and that it may well include vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials. So public officials should know what they're getting into when they run for office and should expect some criticism. I just went over what actual malice means. It's a really high standard. Unless someone has proof that you knew or recklessly disregarded that the statements were false, they're likely not going to be able to get you for defamation, even if the statement is false and all of the other elements are met. And then negligence, if you're reporting about a regular person, that regular person's just going to have to show that you failed to exercise the level of care that a reasonable person would have. So they'll have to prove that you were negligent in verifying the accuracy or gauging the statement's defamatory effect. A couple other things. This is important for journalists in general because it's an intersection of the law and journalistic requirements. Journalists want to make sure that what they're reporting is an accurate reflection of actual court records. So you're protected in Ohio if you're reporting about the content of a lawsuit or a proceeding, so long as you are doing a fair and impartial report of the contents thereof. So if you're sued for defamation and you're reporting on an indictment, a warrant, arrest of a person, you have a privilege and you should be protected, so long as you're giving like an accurate, unbiased account of what is actually included. So if someone's sued and you want to report about the content of the lawsuit, look at the complaint that's filed. Patrick talked about it in the docket. Make sure that when you're talking about the contents of a complaint for the general public to understand, that it's just not your opinion about it, but you're just giving the facts as they are. Again, it doesn't have to be a verbatim reproduction, just has to be substantially accurate, and don't publish with malicious intent. So if someone you don't like has been sued and you want to talk about it, don't be mean or intend to hurt them, just be unbiased. Last, I just want to touch on, I mentioned before that Ohio people will use defamation suits to attack or intimidate or chill the speech of others. There's a big push for us to adopt anti-SLAPP statutes, which would mean if someone sues you for defamation and they have a frivolous claim, it would be easy to get their lawsuit tossed out. 33 states and DC have these suits. Ohio doesn't. So talk to your legislators. It's important to get this in front of the Ohio Senate. An anti-SLAPP bill has been introduced twice in 2017 and 2019. But, if you're hit with a defamation suit and you can't afford to defend yourself, you might say, I'll take this statement off the web, or I'll never say this again, which really goes against democratic engagement. Any questions? Sure.
I just imagine a situation where, like, if you are a journalist and you are attributing someone else for something, like John killed his wife according to his neighbor Paul. In that case, you are attributing someone else. Can you be sued as making defamation?
That, I think, would turn on whether you did your due diligence in verifying the accuracy of the information you're getting. So if your neighbor is telling you this, or their neighbor is saying that the neighbor killed the wife, and this turns out to be false, the case would turn on, okay, so did the journalist act negligently in posting this defamatory statement? Would a reasonable person have done more due diligence in verifying that this was false? If you just listen to what the neighbor says, don't do anything else, and it turns out that he didn't kill his wife, in a case like that, he may have a stronger defamation claim against the journalist. But if you do more reporting and try to be reasonable in gathering your information before you post it, and you're acting reasonably in verifying the accuracy, then you may have more protections as a journalist. But I think, and this is not legal advice, but if just be smart and don't just take someone's word for what it is if you're posting about something as severe as a crime, because Ohio courts look at crimes as very serious, because as soon as you're charged or accused of committing a crime, that immediately hurts your reputation. You're welcome. Yeah. What? I'm sorry, could you repeat that? I don't know. Do you know if privacy violations can be linked with defamation? I'm not
totally sure. I suppose if someone is out there saying you defamed me and you invaded my privacy, they could sue for both. But I don't necessarily know if there's any case law or anything about the interplay between those.
You're welcome. Yeah.
Kind of jumping off of that question, if you're publishing statements that folks have made about a public official that are allegations or something like that you aren't able to independently verify, I'm thinking of a situation when I first started reporting where some members of a village council were saying that the mayor was not a legal resident of the village and shouldn't be able to hold office, which at the time we published, and then the mayor was very upset that we were publishing these unfounded, in her words, allegations against verified members of the council. Is that protected? I mean, that's a different.
It's honestly super fact dependent. So you're talking about a public official, and they're going to have to show, with regards to verifying the accuracy, did you know it was false? Did you know it was false that they didn't live there, or with a reckless disregard of its probable falsity? So in that situation, it would really turn on, what did you do? I think you should always protect yourself. In a situation like that, if it's coming from a a reputable source where you believe they're reputable and you think that from your news gathering that this is true, you could be generally okay. But in a situation like that, you should try on your own to do an extra step to verify, where does this person live? Because it's just going to, the court will think that you're not doing your due diligence. But again, it depends who is making this statement, how reputable they are. Can they be trusted from having gotten their information from a reputable source? Or is it coming from someone who it's not part of their practice or their job to know this about someone who's running for mayor or is the mayor, if that makes sense. You just have to keep in mind, just if you know it's false or you're kind of recklessly disregarding that it's likely false, that's where you're jumping into liability. Yeah.
This isn't a question, it's an observation just for general purposes that there is a lot of talk in certain circles about trying to overturn New York Times versus Sullivan. And Clarence Thomas has publicly stated that the Supreme Court should overturn the Sullivan case. So be aware that there are this, which you would think, which is treated as settled law, may not actually be settled law.
And it's interesting too because the Ohio Supreme Court has adopted these all of the federal high courts, because they're constitutional principles that apply to defamation. Key parts of New York Times are part of how we conduct a defamation analysis. Like another part of that case is that the defamation claim has to be about the plaintiff, and that's integral to how Ohio courts look at it as well. So it would be interesting, not only does it talk about the importance of being able to ridicule public officials, but other constitutional principles. So I would be curious to see how overruling that at the federal level would affect the Ohio Supreme Court's interpretation of defamation. But at least it's part of our law for now in Ohio. Anything else? Thank you.
All right, well, thank you everyone so much for attending here today in person and on the live stream. We really appreciate all the comments and questions that we have received. If you need anything, feel free to reach out to us. We have an active presence on Twitter. You can also email us, Google First Amendment Clinic at Case Western Reserve University School of Law will come up, so there's definitely ways to get in touch with us. We have provided the slides, and so I think that they will be linked to a recording of the live stream. I'm not exactly sure about the details on that yet, but the slides will be provided and are available to you all. So I just want to say thank you to our certified legal interns for leading the presentation today. And thank you all for attending, and have a safe drive home and have a good weekend.